most effective tool for economic development. Those forces are combined altruism and selfishness. Man as a combination of altruistic and selfish forces is the supreme creator not only of commerce, but also regulation for commerce. So the question is, how does it work? How does this combination of altruism and selfishness work out? What kind of practices lead to? Let me compare for you two different commercial transactions. And we'll watch how those two commercial transactions have gotten to have the best type of practices that made it to be highly contributive to economic development. The first one is secured lending. Secured lending is cooperative because usually it allows one party, the borrower, to obtain money or credit in exchange for payment of capital, principal, and interest to the other. That would say is the nuclear transaction. As time developed, you added to this nucleus the ability of the debtor to stay in possession of the goods with which to repay the loan. And as time occurred, then you had suddenly to worry about the third party. That is to say, another creditor who might want to lend, a purchaser of the same goods that could be used as collateral. And at this point, what started out in the road as this type of a transaction, it was the first organized legal system in the world in which you could obtain this type of a loan, i.e., the debtor to remain in possession of the goods, either by way of what they call an hypotheca or a mortgage or a pledge, a pignos, either by that or by the delivery of the thing to the creditor in a typical pledge. Yet, there was no way under Roman law in which you could find out, being a possible creditor or a third party that would be buying goods, whether or not you had the right to do so. What Rome lacked is what Santiago Mexico's registry in Colombia has, what Elsa Ayala's Indiana's registry in Mexico has, which is the ability to access that information from anywhere and find out what's happening to the goods in terms of their collateral value. So in addition to that, Roman law was not very fair-handed. It was a society of tremendous exploitation by the rich and by the landed gentry of their slaves. The slaves were basically the workers and the borrowers. So you find in one of the Roman, not the digest, the institutes and the codex, you find hundreds of petitions by borrowers who had lost their goods, their land, as well as their goods at the hands of the wealthy landowners. And consequently, they petitioned the emperor and the so-called rescripts for equitable relief because they lost everything. Hundreds and hundreds of petitions. What does that tell you? That the Roman pignos and the Roman hypotheca, even though they had the nuclear elements of that loan, lacked two things. They lacked a loan in which there was reciprocity, mutuality, fairness, and a loan in which the third parties could not be protected because there was no registry. So it took until the 13th century in England the so-called Jewish mortgage, which enabled this particular loan to prosper by creating a registry. And it took basically until our days to arrive at a formula of fairness between creditor and debtor in every aspect of the loan before you finally had a workable, secured loan. 2,000 years to develop. Things take a long time in the law to develop, but really, from an economic development standpoint, you have to wait this long. So you have that institution. Contrast this type of a loan with the letter of credit transaction. The letter of credit transaction is a transaction that started being used in the middle of the 19th century, and 100 years later, it was a mature transaction. Billions of people around the world were governed not by codes, by customary rule, and by customary practices. Now, what were these practices? These practices were practices, first of all, written among the everyday participants in that trade. The bankers, a banker would one day issue a credit, it would be called the letter of credit issuer. Another banker would notify the seller beneficiary that the credit has been issued to his favor. Another banker would confirm it, saying, I accept liability as if I were the issuer. Another one would pay. All of these were bankers acting interchangeably. That is to say, one day I am the issuer, tomorrow I am the confirmer, the next day I could be a notifying bank, and then they'll be changing the roles all the time. Now, when you have that type of participation in a commercial transaction, the practices that emerge are likely to be done very quickly, well, and firmly, and fairly. And the question is, why? Why is it that that type of a transaction produces rules such as the Uniform Customs and Practices, which are adopted by 180 nations around the world without enacting laws, without having any type of treaty or anything else like that? Why is it that there is that degree of cooperation? So you ask yourself the question, says, okay, let's see how that rule works. How do you shape a rule like that? I could give you a few examples of how those rules are shaped. I participated in the shaping of these rules. So I could tell you how they were shaped. Let's assume that the rule in question defines bankers are not sure what's the meaning of the term negotiation. One banker thinks that to negotiate a credit is to look at the papers presented by the beneficiary and say, they look, they're okay, and with that, they have negotiated, and with that, they're entitled to claim a commission for negotiation. So, another banker says, well, in order to negotiate, I really have to examine the documents as a bank who's an intermediary bank to the paying bank, and say to the paying bank, I think that these documents are okay, and for that reason I think that you ought to pay for them. You, the issuer of the bank. So let's examine a situation in which, let's say, a bank in Germany issues a letter of credit that is going to be confirmed in the city of Chicago by another bank. And the company named Motorola is the beneficiary, and Motorola will be presenting documents to the bank in Chicago for its quote negotiation of that letter of credit. So I asked the bank in Chicago, I said, okay, Mr. Banker, what do you call negotiation? So he says, well, what I call negotiation is I get the documents from Motorola, I pick up the phone, I call up the banker in New York that confirmed it, and I said, it looks okay to me, you want me to pay it? So the bank in New York would say, yeah, go ahead and pay it. So the bank in Chicago would say, wire me the money with which to pay Motorola. And they do that. And for that, I said, you charge a commission of negotiation. And he says, yes, for that I charge a commission of negotiation. How much is that commission? Well, it's a $50 million credit, so it's likely to be at least $200,000. And I said, so what did you do again for charging those $200,000 to the presenter of the documents? Well, what I did was, I happen to know the banker said that you were acting like a post office. You were not. Do you assume any responsibility if Motorola gets paid by you the money that the principal issuer sent you, and the issuer looks over the document and says, terribly sorry, you made a mistake, the documents are not in accordance with the credit, and they don't give you the money? Do you say to the Motorola responsibility for the issuing banks doing, that is to say that you examine it, says, I examined it, they looked okay. If the issuing bank says, no, they're not okay. You pay the issuing bank, but you paid up. No, I wouldn't do that. So basically, for your giving, for your charging this commission to this other bank, all you've done is pick up the phone and act as an intermediary. Yes, that's the case. So then I asked the other bank, the banker in New York, who had issued a commitment to pay that $1 million and who could not charge a commission for negotiation because somebody else had done it already, and said, is this what you call a negotiation? No, that's not at all. What is it that you call for a negotiation? It says, well, to examine the documents, assume responsibility that they're good or bad, and then if they are, and I assume that responsibility, if for some reason the documents are bad, I take over that responsibility. So I said, so how would you define negotiation? He says, giving something of value. Giving something of value. So then I asked many other bankers around the world, do you agree with version 1 or with version 2? 2 being the issuer, the other one. And I added to that question the following in parentheses. Place yourself in the position of both banks before you answer this question. What do you think was the reply? More than 500 replies around the world. Everybody agreed with the position of the issuer. And the position of the issuer was the guy, this other fellow is not just a banker, he's an SOB. He's using my money, he's using my responsibility, and he's not giving anything to the other side. So this is the beginning of what I call a standard practice. A standard practice is one in which the merchant has to position himself as if he were the other in the transaction. In a standard practice, the merchant has to assume that he will be in the position of the other any other day of the week, any hour of the day, because these are interchangeable functions. That's why part of the letter of credit world immediately acquired its standard practices, because no practice could succeed and meet that standard unless you placed yourself in the position of the other. If you look at the international, the Convention of the Sales of Goods, the Vienna Convention of the Sales of Goods, you will find Article 8.2 of the International Convention of the Sale of Goods. What does that article, I believe, I hope I'm remembering the right number, but so what it says is to be reasonable is to place yourself in the position of the other party as a member of a given trade. So what we're talking about right now is the determination of what is known as archetypal behavior. What is archetypal behavior? Archetypal behavior is one that is representative of respected people in the various trades. So when you're talking about representative people, who are these people? Well, the Romans, again, gave us a pretty good indication. The Romans had a person named the bonus vir. Who was the bonus vir? A great jurist, Ulpian, was once asked the question, the following question. Ulpian was asked whether or not, if I sell a slave, you're not the slave. If I sell a slave and the slave is sold under the condition, and the slave was sold under the condition that the slave had to render accounts to his master before the sale became complete, most Roman jurists that examined that factual situation said that is an illusory sale. A sale will not work. Why not? Because you're giving one of the parties the right to determine whether or not the conditions have been met or not. And that is illusory. Ulpian answers, that is not necessarily an illusory condition. You can always consult the opinion of a bonus vir. Who is a bonus vir? That is a man of affairs, a merchant who's respected interpret those conditions. So from the very beginning of legal thinking, of legal reasoning, in one of the highest, most developed legal systems of the world has ever known, you have this figure of the bonus meter, an archetypal figure, a figure that could be emulated, his conduct could be emulated, and that could be emulated trade by trade. So when we're talking about standard practices and the writing and shaping of standard practices, and incidentally, one of the panels that will be working in this meeting will be shaping or beginning to shape those rules. That's the panel involving electronic warehouse receipts. This is an area where getting together the shippers, carriers, the warehousemen, the depositors, etc., will lead to the formulation of standards that are respectable for the others, because each one will be asked to put himself in the position of the other for this particular type of transaction to become a standard practice. What is then a best practice? What's the difference between a standard and a best practice? The difference is that in a best practice, you're not only concerned about the rights and duties of the regular participants in the transaction, as it was the case of all the banks, issuers, notifiers, payers, negotiators, but also about third parties. Third parties. Very important in commercial law, particularly in a commercial law in which we're living in a world of strangers. Everybody is a stranger in the marketplace today, when we're all communicating ourselves through computerized messages, and we depend, as we do on the internet, to do most of the business of the world. Then the respect and the protection of the third party is absolutely crucial. So a best practice is one in which not only you take into account that which is the best interests of the regular participants in the transaction, but also the best interests of third parties, those who could be affected by the practice in question become third parties. And this is one of the reasons why, when we're talking about simplified companies, we're talking about accounting practices and forms and standards, because that is the way in which you start telling the truth. Telling the truth, or extracting the truth, as accounting did from the very beginning of that profession by developing double entry bookkeeping, was a way to provide third parties, lenders, creditors of all types, buyers, and first in Italy, with as accurate a version possible of what was the state of the finances of the second party. So the standard practice that becomes a third party practices also relies on the determination of duties towards those third parties. And the duties that those practices give you rise to are usually a function or a result of the fiduciary nature of the second party. Fiduciary duties are those that, depending upon the entrustment, the degree of entrustment of one party to the other, and the incapacity, the inability, the contractual weakness or inexperience of the other party, require greater duties. From familial duties to what Justice Cardozo in the United States once referred to as uberrima fides, the maximum degree of good faith. This is a critical component for those commercial practices in which you're going to ask the world to really trust you. If you read the history of the Rothschild family by a very fine Harvard economist and social historian, you will find that at one point the of Prussia, and the fiduciary, Rothschild, decides to display all of his goods, very expensive jewelry, etc., in his house to the clear sight of the Napoleonic army that came in to try to, they found out that this may be the place where the Elector of Hesse's treasure was hidden. So the fiduciary allows the Napoleonic army to see this treasure. They take it, and this way he saves the fortune of the Elector of Hesse. That was the beginning of a trusting relationship that lasted for many years and created the most trusted banking house in Europe. Similarly, the London Goldschmieds, the same ones that started issuing promissory notes and checks and eventually were responsible for the check mechanism in Europe, were known to have handed down the economic value, the monetary value of whatever had been deposited with them as jewelers and bankers after one of the fires of London. What that told people was that you could trust the Goldschmieds, and you could trust their checks and eventually money paper. Even when there was a catastrophe such as they did, they came through. So you know that's the basis of the insurance company in many ways. Had there not been a fiduciary duty, uberri mafidis, beyond the average good faith assigned to that particular practice, then there would have been, why would people give money for just a promise to pay money in the future as insurance and paying premiums and all that? What were they getting back in return? So there had to be a certain amount of giving in order to make sure that that particular practice of which is fiduciary in nature would progress. So now you have standard practices, you have best practices, you have fiduciary practices underlying the world of practices and their formulation. My suggestion is that as lawyers who participate in this process more and more, we need to be aware, number one, of the importance of these practices, because in the world of future commercial law, you will not have codes anymore. There will be very few codes. Very few people will be able to know enough to be able to write responsibly a code for many professions that are now commercial. In our world, contrary to Napoleon's worst expectations and policies, this is a world of merchants. Everybody's a merchant. Lawyers are merchants. Engineers are merchants. Professionals of all types of merchants. Anybody who has a computer will become a merchant. So what used to be a totally isolated occupation in the Middle Ages and even in Napoleonic France has become now perhaps one of the most generalized professions in the world. So with that number of professions, with that number of practices, to assume that you could write the kind of code that was 150 pages long during Napoleon's times is simply utopia. Now, what about the role of the lawyers in this process? More and more, lawyers have to become what I call guardians of good faith. Guardians of the transactional good faith. What is the meaning of that? Imagine what happened in the United States and the rest of the world when many of the most respected banks started issuing perfectly worthless also create land registries. Went to see one of my students at the land registry, and I asked him how things going. He says, I'm very embarrassed, Professor Consolci, not to tell you this, but I had to fire 5 registrars in the last 2 weeks. I said, why? Because they were inventing mortgages that did not exist to be able to be put into the pool of mortgages that was being sold by Prudential, by Bear Stearns, one of the underwriters in New York, everywhere. And I said, did you tell the Bear Stearns people about it? They said, yes, I told them. So what did they do? He told me to speak to their lawyers. So I went and spoke to these people, and then I spoke to them. And I told them, are you aware of the fact that probably 50% of the mortgages in this particular issues are non-existent? So the first reaction by these lawyers, very major law firms, was to tell me, oh, Boris, you don't know what you're talking about. Just see, in order to understand what securitization means, you have to understand that there is a pooling of assets. And we throw in mortgages of all types and different magnitudes and different periods of maturity and different rates of interest, and there's enough of it so that if some are unpayable, then the others will take over. And I hear that almost 50% of those mortgages are non-existent. You don't know what you're talking about. We got opinion letters from top law firms in Costa Rica and in New York saying that there's perfectly good collateral. Were these lawyers really giving their best opinions on it? And the answer, of course, they were aware of what was happening, but there was too much at stake for them to say otherwise. So this is where you start seeing the meaning of good faith and the role of the lawyer in the whole process. The role of a lawyer is a result of understanding the meaning of good faith. Good faith for the Romans was the following: honesty in fact. The Roman praetor used to hand out formulas for the direction of the Roman judge how to find various facts. And under the praetor's formula, there were the so-called exceptio modi, defenses based upon those of fraud. And that notion of those of fraud was one that allowed you to get the formula to be protected from misrepresentations of fact, dishonesty. That is a version of good faith that prevailed for quite a while in the legal world. Now, more and more, as a result of commercial law, you have to rely on a different formula of and meaning of good faith. It's not only honesty in fact, it is acting reasonably in accordance with the standards of that trade. And in addition to that, it's being fair to other trades. If, for example, I know that there is no way in which a contracting party that I'm dealing with could make any money on the basis that I'm supplying any goods or services, because those goods or services truly do not merit the prices that he or she thinks he can charge for it, I'm not acting in good faith. I haven't stolen anything. I'm not dishonest in fact, but I have not acted as if I should have been in the position of the other, or an archetypal other should have acted. And that is the meaning of good faith that requires a lot of work by the lawyers. Because the lawyer's function is not only to put himself in the position of being a defender of all the rights of his clients, but when there are So, coming to the end of these remarks, as we look at the world of new lawmaking, new commercial lawmaking, we have to, number one, keep in mind that the eras of the codes is done. Number two, that the era of practices, particularly standard and best practices, is in. That the role of the lawyers is to be a guardian of an enlarged notion of good faith, which is not merely acting honestly in fact, but acting also reasonably, taking account the considerations of the other. So we have to do that from the very beginning of legal education by doing what has not been done in many places. It was not done in my education, which is to familiarize the lawyer with the actual facts of the transaction. The successful commercial lawyer of the future cannot be just an issuer of abstract legal opinions or of very, very conceptually technical contracts. He's got to understand, or she has to understand, how that contract works, how the parties make a living, how do they expect to be making a living, what are the consequences of this contract for the parties in specific and for the third parties in general, for society at large as well. Because lawyers will very much make the difference between, say, a developing nation truly developing and just carrying on for years without being able to attain any level of development. So as we sit here today and we get going on this attempt, which I think one can say without exaggeration is going to be historic, because it's the first one that is being done between countries of Latin America, countries in Asia, to try to arrive at a set of standard best practices in 5 different areas of the law in which they're